see any glazed faces yet, so that's good. Public meetings. I think the most important thing to know about public meetings is Roberta. So, I mean, that's that's kind of the answer right there. She's been doing this for a while now and has a very good handle on this stuff. So she's your best resource. And if she is ever stumped, she'll consult with Michelle, and then she'll consult with me, and we'll get you an answer. But that's the first thing to know is you have a friend in Roberta. So this is the purpose. I've copied the statute here. This is the purpose of the Public Meetings Law. And the background for the Public Meetings Law, as you probably know, these were adopted in the 70s after Watergate, and these are kind of classified as what we would know as sunshine laws. They saw what was going down in Washington, D.C., and they didn't like it, and so at the local and state levels, they started enacting these laws called sunshine laws so that the government would take place out in the sunshine, out for the public to see. So we have right here, we're in a public meeting. I'm on camera, and I'm being video, audio recorded, and there's a record of everything that's happening. So we're doing it all out in the open, and we're not hiding the ball. And so this is a starting point for all public meetings. Questions that go before a court. The court will read this purpose statement to answer any questions. And it talks about the public has the right to be aware of the deliberations, so you talking amongst each other, your decisions, your final pronouncement on things, and also the information that you're receiving. And so I underlined those three words because it's more than just making decisions out in public. It's actually talking in public and then getting information in public. So those are the three keys to any public meeting and any public decision. And you really need to be having those three things out in the open. The public has a right to know what you're doing, how you made your decisions, and what you made your decisions on. So the next slide talks about how a meeting is defined in public records law. And a meeting is the convening of the city council, for which a quorum is required in order to make a decision. So you only can make a decision if you have 4 votes. And so if 4 of you are ever meeting, that is a quorum of the city council. So this red flag should be going up. Are we deliberating? Are we having a meeting? Is this a problem? Now, the next bullet talks about a violation of the Public Meetings Law. And it says a quorum of a governing body may not meet in private. And now notice that Public Meetings Law defined what a meeting is, and then it defines a violation as to meet. The Court of Appeals has said those are 2 different words, and so they have 2 different meanings. So there are regulations that define how you hold a public meeting, but you can be in violation of the Public Meetings Law if you meet in private. So the Court of Appeals has struggled with that distinction and has said, well, that has allowed them to expand what to meet means. And so we'll talk a little bit about that, and that's how we get to those serial discussions, email, and all of that. And so to meet means something different. So the next slide is, this will basically summarize a few slides that we're going to skip. And it's, oh, I'm sorry, that's not yet. Yes, I'm sorry, geez. What meetings are subject to the law? So this is how we get to violations. And it talks about, we've learned these actually from the Handy cases. There are 2 different Court of Appeals cases involving the Wayne County Board of Commissioners, and they expanded upon what you might think of as a meeting and what it means to meet. So serial discussions can be a violation. It's contemporaneous gathering of a quorum, not required to meet. So even though you don't have 4 people in the same room, you can still have a violation if you then have 2 people in a room and 2 people in another room, and then one person goes back and forth. And then you take it on the electronic level, and you talk about email. What if you have 4 people who are never in the same room, but we're all exchanging emails in rapid fashion? And the court is kind of like, well, how's that different from a meeting? It's not. I mean, you're exchanging, you're deliberating, you're exchanging information, you're discussing, you may be even arriving at decisions. You're not all in the same room, and it may not even actually be contemporaneous. It may not be, rapid fire email, maybe over a period of days. But how is that different than a meeting? The court is basically saying it's not. So you can have a violation. And interestingly enough, the court has actually talked about communication through intermediaries. So that would be a case where maybe the mayor talks to one counselor, gets the counselor's opinion, and then goes talk to the third counselor, and then shares that second counselor's opinion with the third. So the mayor is now the intermediary. He's basically taking votes in his pocket, and then he's walking around the table and picking up more votes. And so that is communicating through an intermediary. And so you've got to worry about, hey, if I'm telling you all what Amy thought about this issue, am I now bringing her into this illegal meeting? That can be a problem. The one saving grace there is the last bullet, and that's administrative matters. And that's when Roberta or Michelle are communicating with you all about setting up meetings or scheduling. Purely administrative matters, even if you're exchanging thoughts and decisions on those administrative matters, that is not a meeting, because it's just allowing you to schedule that meeting. It's allowing you to get to the public. So no, I'm not available on that day, but I am available on this day. If everyone knows that, that is not a problem.
I feel like mentioning that final point about emailing, where we don't reply at all.
Yep.
Because it kind of looks like we're meeting accidentally. So if Michelle sends a message to all of us, you don't reply to everybody, you reply to Michelle. And then it doesn't look like that.
Yeah. So that's a great practice to get into, and that's one you've had for a while. Yeah. So that's. So this next slide just describes what is required for a public meeting, and it explains to you why it's important, why we don't have private meetings. Because Roberta has to do all this stuff. This is what, if this doesn't happen, then we've done something wrong. And this is her job. And so if you're having a private meeting, you didn't provide notice, you didn't have a proper space, the location wasn't probably accessible. And if there were votes, even if you didn't think there were votes, they weren't being recorded, and then the minutes weren't being taken. So this is Roberta's job, and if we're out there outside of council chambers, she's not able to do her job, and she's not able to make sure it's lawful.
I just want to say this also applies to all their committee meetings.
Yes.
Quick right there. Did you have a question, Mary?
Yes. I wanted to clarify whether something like this, a work session, because you're not voting on matters, is it still considered a public meeting?
Yes.
Okay. And like you just mentioned, subcommittee, when they meet, those are all public meetings, so they would probably require minutes and...
Yeah,
okay.
yeah, so this
Yeah.
meeting was noticed.
And noticed.
And we have a recording going, and we have a minute taker.
Okay, thank you.
So I'm gonna skip the slides here about the handy cases, because I know you haven't all heard this, but I've told you all about this several times now. It's just, if you wanna read through it, it's interesting. It is an extreme case, but it set some law for us, and it helped me explain to you all what the rules are. So it's certainly an extreme situation, but it led to some case law, and it led to how we understand the meetings law currently. So into practical tips. And this is exactly what Martha was just talking about. So these are three bullet points. These are my tips. These are not rules. This is not the law. This is my conservative advice to you as your legal counsel to absolutely stay out of trouble. I fully recognize that you cannot always follow these tips, and that's what I'm saying. This is not the law. This is if you have these tips in your pocket, this will keep you out of trouble, and then when you have to vary from these tips, you'll know why you're doing so, and do it with caution. So avoid replying to emails, and that's just avoid replying all, but also replying to any council email. And I know that's not always practical. I know these are just my tips, they're not the law. But if you can avoid any reply to a council email on a non-scheduling issue, then you're home free, because there's been no discussion. If you want to reply to the mayor's email, save it for a public meeting. And say, hey mayor, I noticed your email from last week said this, and I want to say this about that. Well, now you've replied in a public session, and that's the best way to do that. Avoid conversations, so in person or via email, between councilors where the views of fellow councilors are shared. This is that intermediary thing. So if you have someone else's views or someone else's vote or someone else's thought in your pocket when you go talk to someone else, that can be a problem. Because now you're not only talking for you, you're talking for two people or three. And if it's for three, that's a real problem, because now you have four. So you need to be careful. So avoid having those conversations where you're talking about policy issues, city business, when you know someone else's stance on it. And then the last one is kind of the, let's not have a vote in private. It's avoid sharing your firm opinions or views on items that the council would need to vote on. So we all know we're gonna come back next time and talk about Santa Fe. We're gonna talk about recycling, yard waste. I think we all expressed opinions about that tonight in a public meeting. That was great. Let's not have that conversation between now and February anywhere else but in a public meeting. Let's not share those views with fellow councilors via email or at the coffee shop, at the bakery. Let's keep those to ourselves until we get to the public meeting, and then share those with your fellow councilors in a public session.
You can share information with email.
Well,
If you know we're coming up on a session and you want information or something like that, you can communicate with me so that I can make sure that everyone has the same information at the meeting.
Michelle, great point. Yeah, so we're talking about inter-council issues here, the inter-council communication. Michelle is your always at the table, but she's not a member of the council. She's not a vote, so we don't really count her in this issue. She doesn't count.
That doesn't seem right.
A little harsh, geez.
Yeah.
Come on, man. This next slide is the practical tips for running a meeting, and I have to say that this is the one slide in this presentation that evolves over time for me, and I will say that I worked with Mayor Stram on this quite a bit, and we worked through these issues, and I've added and taken off some of these over time, working with Dave, and I think he did a great job overall. Some of his meetings ran a little long, but overall he did a great job of sticking to this list. And the first one is for the mayor. You've got to set a realistic agenda. We can't be here until 10, 11 at night. That people can't make good decisions after being in the same room for 4 hours, being hounded by information. It's just not, I don't think it's humanly possible. So, and it's not fair to you're all volunteers, so it's not fair to you. You've got families to take care of, and be with, and jobs, to do. So, it's just not fair. And so setting a realistic agenda, that's Mayor and Michelle's job to make sure that you guys can get through, anything, okay. To make sure that you guys can get through the items in a reasonable amount of time. I know there are exceptions, sometimes you just have to do it. Budget season maybe is one of those times where you have some longer meetings, or they start stacking up, you have multiple meetings. But if we can, overall, if we can keep those realistic, that treats you fairly, it treats our audience fairly, and it's the best way to do business. Yeah, Roberta is one of the best at getting you materials early and in advance. We know you're busy, and so she gives you options on when to review the packet. She gets it to you early, and you have your choice of days and evenings to review it. Sometimes it's hard on staff to get her materials in time, but we do our best, because it's fair for you, to allow you the time, and then your job then is to review them and make sure you come prepared. You have great simple rules. Your council rules are understandable and simple. You keep things formal, and you do things regular and pretty uniform all the time. That's great, and so people know what to expect. Public participation does not always mean public conversation, and I think you also do that well. I think Dave was great at that, acknowledging audience members when it was appropriate, but otherwise, this is the council's business. This is your time to do your work, and they can observe, but this is your time to get things done. You use work sessions. That's actually something that's relatively new here in Creswell, and I think I worked on Michelle and Dave long enough to get that. So now you're doing that all the time, and I think it's a great use of time. It's great to bring the body down here and have this discussion. It's a public meeting, people can observe, but this is your time to work things out. Have that conversation at the same level.
One thing I can say about work sessions, and I think we can all agree on that, is that it makes our council meetings, when we actually do make the decisions, much more streamlined, much more time constraint, limited as far as that goes, and we can actually make our decisions in a timely fashion and in a public way, and it really has worked out well. So I'm really thankful that we do have this and the commitment to do that.
Yeah, absolutely. And just last, I'll say, and especially for the new counselors, get comfortable having these discussions in open. It's beneficial for you and for your fellow counselors, and for the audience to hear what you actually have to say on these subjects. I know it can be uncomfortable sometimes to speak in public. I know sometimes it can be uncomfortable to disagree with your very friendly colleagues, but it's okay to disagree. Do it respectfully and honestly, and they'll return the favor. But it's okay to have those conversations in public. The next slide is my only one on executive sessions, because they don't happen too often here in Creswell anymore. I know there were days or years when we had quite a few executive sessions, but we don't have them too often anymore. And Roberta handles it, so there's no real problem. There's not too much you need to know about executive sessions. Executive sessions are the ability for the council to meet outside of the public. So we usually go in the back room. The newspaper is usually there, but the public is not there, and that allows us to have a frank and honest communication on very select subjects. Often it's conferring with me about legal advice. So if we're involved in some litigation or something like that, and you need to talk to your attorney about that litigation, or settling a litigation, or going to trial on that litigation, we need to have that conversation where the attorney-client privilege is protected, so we need to have that communication outside of the public, and the public meetings law allows that. And so we follow the book on how to call those, and we follow the book on what can go on, and we don't make decisions in executive session, but we can have those conversations.
We actually have 3 a year now because we've can also use executive sessions when evaluating our employees, which we have 3 of, and so we will have 3 a year now.
Very true. Yep, absolutely.
Get this stuff, HR and litigation.
Real estate.
Yeah, actually, real estate is actually probably the one that we've used the most recently, and so that, it allows you to talk to the person who's handling your real estate transactions for you, which is usually Michelle, and give her guidance on how to proceed on a real estate transaction. And that just makes sense if you think about it. It levels the playing field. So the private party is out there talking to their real estate agent in private. How come we can't? If we're trying to make, we won't accept $1, over X, well, now we've just told the whole public that's not fair. Or we will only, we want a lease for this much and we can't pay a penny more. Well, now everyone knows. So we're allowed to have that conversation in private. We're cruising right along. We're gonna get to ethics this time.
43 and a half minutes to go.
Okay. Public records. Public records is short as well. Again, because we have Roberta. The public records law governs the records of the city. And again, this came about the same time as the public meetings law, and it was part of the Sunshine Law. And so as part of holding your meetings in public, the Sunshine Law as to public records means that the documents that the city has should be out in the public as well. And so what is a public record? It's basically everything. Let's just start with that basic premise. Every document of the city is basically a public record. And of course, there are things around the edges where I will quibble with that statement as an attorney, but overall, everything the city produces, everything the city takes in and puts out is a public record, regardless of form. So even though this is a really old law, it's been modernized in terms of interpretation. It's a 1970s law when faxes were the norm, but now we apply it to email and everything else. So regardless of form, to us means electronic communication. Yes?
My question was asked prior to our meeting tonight in regards to, especially from new counselors, is talking about how much documentation there is going to be as a council. And the retention policy is going to be something that came up. So if, like for example, on my agenda, I'm highlighting and I'm also Xing on agenda items, so I'm staying on top of where we are in the meetings. So henceforth, that being altered from its original state is something I need to either keep or turn in at the end of the meeting to revert at. So at what point, I mean, if I were to just highlight these, it's still technically the same document without any notes. Is that something that then would have, that again have to fall under records retention?
I think there isn't really black letter law on the answer to that. So my general interpretation is if you make meaningful substantive changes to a document. So notes, if you're taking notes on the agenda where you're making reminders to yourself about certain subjects or how, remember to vote yes on this, that's a substantive change to that document. So that's now a new document. I think highlighting and check marks are substantive changes. I think that is not a new document in my mind. And then in terms of records retention, I forget what Roberta's practice is, but I think for every counselor, you should have a binder at home, which is City Council 2019. And it's where you keep all of your city council agendas, all of your documents for 2019. And I don't know if you want that at the end of the year. Is that how you do it at the end of the year? So once a year, you'll have 2019, and then you can offload it to Roberta. And then that's not your problem anymore. Yeah, Roberta. She gets to worry about records retention. I don't want to discourage you from taking notes. But I know there are some counselors who hear that and are like, oh, well, putting down my pen. But how you best retain information is the way to do When we're talking about public records, we talk a lot about exceptions to the public records law. We talk about exempt records a lot. But I want, just because that's how we talk about the public records law, I want to make sure that you understand the baseline is that this is a sunshine law and a disclosure law. So the baseline is that all records are disclosable. Now there's a laundry list in state statute, and there's some additional in case law that allow the city to withhold certain documents, and that's the exception. But that's the exception. The rule is that documents are open to the public. So when a court looks at a question in the public meeting law, it starts with that baseline assumption, that this is a sunshine law, that these documents should be available to the public, and that they should be disclosable unless there's an exception. And then even if there's an exception that applies, a lot of times there's a public benefits balancing test that applies as well. So you can have an exempt public document that I would say don't disclose, but a court will say, no, you gotta disclose it because it's to the public benefit. An example of that would be from an actual case. There was an investigation of a police officer, and it resulted in this police officer being disciplined. A newspaper wanted to get their hands on that investigation and that report, and that is usually not disclosable. A personnel investigation is usually exempt from public records. But the court said, well, this is a very high-profile matter. It was in the news a lot. A lot of people cared about it, and this is a police officer who was a high-ranking police officer. I think it was a police chief. So it's a person in a very important position, and so the judge said, I'm going to rule that this is disclosable because the public benefits trump the public entities exception. So we already touched on this slide. Roberta is our records custodian, and you're going to cooperate with her. And you know, I throw this in there. The council must cooperate with the city recorder. It's because she has a hard job when she gets a public records request, and sometimes she relies on you all to supply her with those documents. And so we just talked about maybe you're keeping your 2019 file folder, or sometimes we'll get a public records request that calls for documents in that file folder. So you got to cooperate with Roberta. Those aren't your records. You're just hanging on to them for her until you hand over the binder at the end of the year. So if we get a public records request in November that calls for certain documents, and we think maybe some of those documents are in your file folder or in your binder, you got to work with us to get them. And if you don't, you know, I've actually dealt with some cities where we get a recalcitrant city councilor who refuses to participate. And my advice to them is you are now acting outside of the scope of your duties by withholding that document. So what you do with that information is now yours, but if we get sued, I'm not gonna be your attorney. So you make a decision you wanna make. I can't tell you what to do. I can just tell you what my advice is to the city. And on behalf of the city, I'm saying you are not acting within the scope of your duties because you're disregarding the city recorder and her obligations. Never had that problem in Creswell, of course. This next slide, now we get the ethics. And this next slide is for Roberta. This is a reminder of your statement of economic interests.